primer on substantive due process. I like this quote that I pulled from a Virginia Law Review article called Substantive Due Process in the Constitutional Text. And it reads that, it opens with this: a reader of the Supreme Court's substantive due process cases can come to feel like a moviegoer who arrived late and missed a crucial bit of exposition, which I realized is a really apt description of how you all must have felt like when you read it in Chapter 9. Now, your authors try not to focus too much on substantive due process. Their goal was to explain to you the results of that legal doctrine, listing all the cases about privacy, that sort of thing. And you can find some information about substantive due process, of course, in the actual text of the book, along the lines of pages 366 through 368, and in some of the footnotes. But like I said, it requires some more discussion. Now, I have found, I think I mentioned in an announcement that I made, I have placed on Blackboard a few law review articles that discuss substantive due process. And some of them discuss it in an objective way, and some of them discuss it in a negative way, and most people discuss it not in an entirely positive way. Even those who subscribe to it understand and believe that substantive due process is a complicated topic and shouldn't just be applied willy-nilly by the court. And when I say applied by the court, they shouldn't use substantive due process to just okay anything. So that's what I mean. And generally speaking, the court always talks about absolutes, right? I mean, we've seen that with the freedom of the press, the freedom of speech, things like that. So let's move on. And instead of talking about substantive due process, what I like to do is funnel down. So let's start out really broad and say, what is due process? Because that's where substantive due process comes from. So due process is asserted in the Constitution. Due process is a legal concept that nobody argues with. Are we required to have due process as citizens of the U.S.? Absolutely. What's at stake, or rather what's complicated, is what kind of due process. And we'll talk about the two different kinds, procedural and substantive, later. So it's asserted in the Constitution, and it stems from two amendments, the Fifth Amendment and the 14th Amendment. No person shall be deprived of life, liberty, and property without the due process of law. So the Fifth Amendment concerns protection, due process concerning protection from the federal government, and the 14th Amendment concerns due process protection from the state government, or protection from the state government via due process. Now, unequivocally, every legal scholar, every justice agrees that due process is certainly a part of the Constitution. It is a legitimate legal doctrine, and that due process is about process. So it's about procedures. So when we look at the process or rather the process portion of due process, you go back to the 14th and 5th Amendments. It's all about no state, no person shall be deprived of life, liberty, and property without due process. And so that tells us one thing, and you can see under the bullet point here, can people be denied of life, liberty, and property? Yes. However, they can't be denied these things, life, liberty, and property, without the due process of law. And no matter what, that is unequivocally, everybody agrees that's true about due process. That's not the controversial part. In addition to the uncontroversial part, or the part of due process that everybody agrees with, the process part, everybody agrees that it has to do with procedural law or procedural rights. So everybody agrees due process concerns procedural rights, which is essentially just the right to a fair process. Now, over time, when the court when the court asserts what is due process, sometimes it goes through some evolution, sometimes it goes through some changes. For example, we know that due process for criminals, or the rights of the accused, is defined in terms of there's a distinct process of, the Miranda rights. There's a distinct process that the court lays out to assign somebody the right to counsel, when to do it, in what cases to do it, that sort of thing. So that's procedural law that the court puts forth, and people may agree with different parts of the procedure, but not, there's never a disagreement about whether or not the court can create these procedural laws or procedural rights. So the procedural law is an attempt to ensure due process, and it's an attempt to pursue procedural rights, right? Fairness, justice. Sometimes the U.S. and state constitutions are very specific with procedural rights. So we have the right to counsel, we have the right to a trial by jury. But even those seemingly specific procedural rights require some spelling out, right? And which I just described when we think about the Miranda rights, when we think about somebody really having the access to counsel. What does that mean? Well, it means letting them know that they don't have to say anything or talk with police officers in an interrogation without having a lawyer. Now, so far, I'm talking a lot about the rights of the accused. I'm talking a lot about what we looked at, excuse me, in chapters 10 and 11. And that's because usually when we think about procedural law, procedural rights, that's what we're considering. But one thing's for sure, if you see the bottom bullet point here, that it is the government's obligation through checks and balances to ensure that these procedural rights are carried out properly. And so here's how we do that. Like I said, the Constitution lists our rights, the governing documents list our rights, but rights are often specified, these procedural rights and laws are specified by state and federal laws, right? And then finally, when state and federal government adopts laws that concern procedural rights, higher state and federal courts ensure that government follows these procedures according to the meaning of the Constitution. And the meaning of the Constitution, there can be some, if you're looking at procedural laws and you're looking at, so what procedures really follow the meaning of the Constitution, if there's controversy in procedural law, this is where it's at. Meaning of the Constitution, right? So is whatever procedure that the Supreme Court deems or the law deems necessary, does that really embody what the Constitution meant? And that's where some controversy is. But again, everybody agrees, procedural law, procedural rights, the right to a fair process, that's okay. And also agree that there might be times when the government can deprive us legally of life, liberty, and property. So we've talked about due process. No controversy there. It says it in the Constitution. We've talked about procedural rights and laws. Due process is about process. So let's look at the other half of due process. There's procedural rights and then there's substantive rights. So now let me tell you the more controversial side, substantive rights. All agree that due process includes procedural rights. I've said that. Only some agree that due process includes substantive rights. So when we talk about substantive rights, it stems from the question of what is life, what is liberty, what is property? Okay, so life, obviously, we kind of get that, right? The right to live, but property, yes, all right, eminent domain, and it makes me think of tort law, things like that. But life and liberty, especially liberty, is kind of where things, I don't want to say begin to break down, but it's where things begin to, or ideas, legal doctrine begins to diverge. Right? So what is liberty? Well, is liberty only that which is laid out in the U.S. Constitution? Some people think so. When we consider the right to religion, the right to bear arms, the right to, I'm forgetting all the other rights that we have, but all of those things that are listed in the 10 Amendments, nobody argues with the fact that those are all included in the question here, what is the right to life, liberty, and property? All right. So then, what if it's something that the Constitution doesn't explicitly say, right? So what if the court finds that there is a tacit understanding of liberty, like among the explicit rights? I can explain that better. So let's go to the second bullet point. major bullet point. Substantive rights are general intrinsic rights of citizens that are not explicitly stated in the Constitution and that the government has no right to infringe upon. An example of this, SCOTUS has noted, is the right to privacy in the marital bedroom, the right to use contraceptives, the rights to do what you want in your marital bedroom. All right, so nowhere in the Constitution does it say that we have the right to use whatever contraceptive or to use contraceptives, right? It doesn't say whether or not there's a right to practice whatever sexual acts you want to practice. That's not specified in the Constitution, thank goodness. But when we look at the overall, and when I say we, I mean justices. When justices look at the overall, what's the intent of the framers here when we look at substantive rights, or rather when we look at the rights that are laid out in the Constitution, when we look at those explicitly stated rights, what is kind of inferred in those explicitly stated rights? So let me be clear. Substantive rights are not those that are explicitly stated in the Constitution. Substantive rights are those rights that we infer from the explicitly stated rights in the Constitution. Now, substantive due process, I just told you what substantive rights are. And substantive due process is the legal doctrine or theory, however you want to call it, legal doctrine, legal theory, legal precedent, you can call them precedents, principles, but all of this is the legal doctrine, theory, principle that the right to due process in the 5th and 14th Amendment include the protection of 1, procedural rights, and 2, substantive rights. So that's what we look at with substantive due process. That it includes not only procedural rights, but substantive rights that are not explicitly stated. And this is something that I think your text did a good job in discussing with you. And this is kind of like the heart of what is substantive due process, right? It's rights that are inferred from explicit rights in the Constitution. It's those tacit rights that aren't explicitly laid out. So let's move on. All right, so I did want to talk about the fact that, well, 2 things. I want to make sure that when you go on and you think about substantive due process and the controversy surrounding it, I want you to know why it's controversial. I want you to know why it requires so many articles. There's books written on substantive due process, law articles, things like that. And to be fair, trying to encapsulate substantive due process in a 200-word paragraph is probably not adequate. Actually, it's probably not adequate. I mean, you could do it, but it's not adequate if you really want to dig into it. So if you Google substantive due process, which I know some of you did, you'll find tons of different descriptions. You'll find it in terms of these are the cases where the court used substantive due process. Sometimes if you Google substantive due process, you'll find cases where the courts didn't explicitly say substantive due process, but it's clear that they used it. That they inferred some sort of right from another explicitly stated right, even though they didn't say specifically, we're using substantive due process. Sometimes you find very distinct definitions. Sometimes the definitions are vague. But there's tons of stuff written about substantive due process. So how do you sort through it all? Is it all correct? Well, in my search, yeah. Whenever I did Google Scholar, when I looked at, even looking at sites like Wikipedia and Ballotpedia, and you should always look at those sites with a little more scrutiny. Look who wrote it. Look who cited, but they all look really legitimate to me. Just kind of like the initial pass when you Google substantive due process. And so I've pulled together what I've seen overall in just a quick Google search. What can we say about it overall? Because you get tons of information, so what can we say about it? So first, all justices, whether they hate it or love it, agree that substantive due process, SDP, is 1, a legal doctrine used by SCOTUS in the past. Right? Even those who don't like it agree it is a legal doctrine that's used by SCOTUS. Who doesn't like substantive due process? Here's something interesting. Hugo Black, not a fan at all. In addition, Justice Scalia, right? So we have two people on the opposite ends of the ideological spectrum who both agree substantive due process, not okay. Now, if you remember, Hugo Black is very he's very much in favor of taking the Constitution at face value, right? So if there is freedom of speech, remember when we talked about the First Amendment rights, Hugo Black was the one that asserted over and over again, they're absolute. These rights are absolute. They're absolute. And of course, we know that Justice Scalia is a textualist, or practices textualism, however you want to say it. And so it kind of makes sense when you look at it that way. So illegal doctrine is used by SCOTUS in the past. That's what everybody agrees it is. Justices also agree that it is most definitely rooted in English common law traditions. So they all assert that it's a tradition to use substantive due process, okay? Meaning, when you think about kind of, how we derive what is known as liberty from the writings of John Locke, and John Locke is rooted, or English common law comes from his idea of life, liberty, and property. I mean, the American founders plagiarized that from him. Of course, Jefferson changed it a little bit with the pursuit of happiness, but at any rate. Okay, so here we go. Now, finally, all justices, haters and lovers, agree that STP is not explicitly stated or defined in the Constitution. Of course they know that it's not explicitly stated, because remember, the very definition, let's go back, of substantive rights are intrinsic rights. Right. So, I mean, the reason that they're not called rights in general is because they are not explicitly stated. All right. So now some justices think, and this is just kind of an array of different ideas, but some justices think that substantive due process is definitely a legitimate doctrine derived from the U.S. Constitution, legal tradition, and the framers' intent. Some justices sincerely believe that. Some sincerely believe that substantive due process is not really a legitimate legal doctrine, but it's been used for so long that now it's acceptable jurisprudence, and so just lean into it, especially those justices who really, really adhere to precedent. So think about Sandra Day O'Connor, who did not agree with the ruling on abortion. But the ruling on abortion in Roe v. Wade set a precedent for substantive due process, embodied a substantive due process and embodied the right to privacy. And she had such a reverence for precedent and the need for the courts to be stable in how they administer the law, that when she had the opportunity to overturn it, she didn't. Right? And Scalia kind of has said this too in the past. In fact, I read some oral arguments where Justice Scalia said to somebody, it was in this, actually, I should probably post this, but he's hearing some oral arguments about the Second Amendment. So this was probably Heller or McDonald v. City of Chicago. So he's hearing these arguments, and the lawyer is arguing not based on substantive due process. He's arguing in favor of, the Second Amendment and in favor of the rights to bear arms. But he argued it in terms of the Privileges and Immunities Clause. Now, this may seem unrelated, but listen, okay? With the Privileges and Immunities Clause, we know that from the first few chapters of the book, the court has said that Privileges and Immunities Clause can't be used for incorporation. That's it. That it's about due process. In the midst of this lawyer's argument, Scalia stops him and says, why are you insisting on arguing this, your case, rooted in immunities and privileges? And the lawyer responded and said, well, because, substantive due process is not a legitimate legal doctrine, and he didn't I want to say didn't believe in it, but I mean it exists, but he didn't think it was a legitimate legal doctrine. And Scalia said, but your desire is to win your case. You know that substantive due process is already used and accepted by the court, why on earth would you not use it when you know that it is an accepted doctrine used by the court? Why try to root your argument in something that the court has previously said incorporation can't be rooted in privileges and immunities? And Scalia, even, like I said, he's not a fan. He does not like substantive due process. He thinks that it's too much inference and too much power for the judiciary. But his point was that, so you may not think it's a legitimate legal doctrine, but it's acceptable jurisprudence now. So let's work within the system that we have, so to speak, okay? At least if you're a lawyer. Some justices think that substantive due process is a made-up legal doctrine or legal principle that's simply used by justices so they can justify their desired legal outcome with whatever case they want. The Constitution doesn't say X, that's fine. Let's say that Constitution's use of the right of X implies the right of Y, and whatever Y is, that is what we get from substantive due process. All right, so, but of course, this idea, justices thinking that it's a principle used to justify their desired legal outcome, this is what a lot of Supreme Court justices think, that, again, so if we think about when substantive due process was really used, your book talks about two big eras. The first era was when the Supreme Court was taking up a lot of cases about the regulation of the economy and the idea that intrinsically in all of these rights listed in the Bill of Rights, that it implies the ability for private businesses, private individuals to make their own decisions with whatever contract they make with their employer. Okay, and for the federal government to just kind of stay out of it, So that was the first use of it. So it was economic use. And then it resurfaced again around the time of the New Deal. And then let's back up. How the New Deal era treats substantive due process is very interesting. And what I should probably do right now is kind of stay away from it because I think it'll confuse you all even more. But there are some books that are written specifically in an effort to deal with substantive due process and its use during the New Deal. Okay, so during the New Deal, technically, during the New Deal, most Supreme Court justices, especially once they okayed a lot of those New Deal, this new progressive legislation, they did not embrace substantive due process. That substantive due process was a time that where the court was very conservative in what government could do. So again, if you don't understand what I'm trying to relate here about the New Deal and substantive due process, that's fine. You don't have to understand it in order for us to move forward. But if you have time, perhaps go and look at how the court treated it during the New Deal. And this is where we get a lot of Hugo Black's backlash against it too. Now, speaking of Hugo Black, the last bullet point here, some justices view substantive due process as SCOTUS's opportunity to sit as a, quote, super legislature to weigh the wisdom of legislation. And that is a quote from Hugo Black himself, that this is a significant overreach of the judiciary's power. And that essentially what they're doing is trying to decide what legislation is legitimate to them and what isn't, when legislation is not to be decided by the Supreme Court, but it's to be decided by the elected branch of individuals, the legislature. In this particular Supreme Court case that Hugo Black, it was actually a dissent that he was talking about this in. I think it was a dissent. Anyway, he was talking about how, I won't go into that, just didn't think that the Supreme Court should be a supreme legislature. Separation of powers, checks and balances, all that. So all of this is to say, you're going to find a lot of information on substantive due process. It's complicated. And I can, by the end of this lecture, kind of give you, I can tell you how to think about substantive due process. What I want you to know, though, is two big things. The first is it's not as easy of a concept to understand as you think. Okay, that's what I want you to understand. I don't want you to take it at face value necessarily and just say, like, this is it. And there's a distinct definition out there for it. That there's a lot of facets to it. A lot of people like it, a lot of people don't. A lot of people think it can be used for good. Most people think it can be used for overreach of power. Now, let me give you some notes on legal doctrine in general. So we've zoomed out. We started the lecture zooming out on due process, and then we zoomed in. We funneled in on substantive due process. And now we're going to zoom out again, even further. Okay, so we're going to funnel out even more and not just talk about due process, but we're going to talk about legal doctrines in general. Where does legal doctrine come from? And remember, legal doctrine is, you can call it theory, legal principle, legal standards, legal precedent. Where does it come from? So it comes from a couple of places. The first is legal tradition, and the second is governing documents like either the state constitution or the U.S. Constitution. And of course, they're kind of one and the same because the U.S. Constitution has a lot of influence from legal tradition. Now, a lot of people ask, does the Constitution specify legal doctrine? And you might be saying, Professor Davis, that sentence is not what you said. That sentence doesn't make sense. And I would say to you, you're right. But what would one of my lectures be without some typo in the actual slides? And I don't want to disappoint. So here we go. What I say is, does the Constitution specific legal doctrine? I sound like Charlie Kelly from It's Always Sunny. That's how I write anyway. But what I mean to say is, does it specify legal doctrine? Like, does it give specific legal doctrine? And my answer to you is, not really. Yet, legal doctrine is derived from it. So it doesn't say it really, it's not specific, but it's derived from it. So what does that tell us? Well, pause that for a second, all right? And let's move on, and then I'm going to come back to this kind of at the end of the lecture. Actually, I don't need to do that. Instead, let me say this. Does the Constitution have specific legal doctrine? Not really, but it's derived from the U.S. Constitution. The second sentence kind of flows very nicely from this. It's almost as though I planned this lecture. Derived from the Constitution implies that, well, it's inferred. So then, who infers the legal doctrine from the U.S. Constitution if it's not explicitly stated? And the answer is anyone can. Legal scholars, lawyers, justices, etc. Right? Anybody can. You can write a paper about legal doctrine. Right now, you can. It might not be published, but anyway, so then when does legal doctrine become official? Well, when SCOTUS asserts it or uses it in an opinion, and sometimes just using it in the dissenting opinion or the concurring opinion, it can be picked up later, then it becomes official. Like official in terms of, precedent. Or this is a doctrine that the Supreme Court asserts. Now, is legal doctrine considered legitimate? Yeah, sure. Unless you think it's not legitimate. And then it's not legitimate. So yes and no, okay? So then, what makes legal doctrine legitimate? And this is probably what this is the most important thing I want you to take from this slide. Aside from, legal doctrine is often inferred or is inferred. What makes legal doctrine legitimate is how people perceive, when I say people, I mean anybody, but Supreme Court justices, how they perceive the relationship between whatever doctrine is being asserted and the constitutional text. So if there is a really significant, justifiable link between the text and the doctrine, everybody agrees it's legitimate. The trouble is this. The very fact that whatever the right is being discussed, or whatever the doctrine is that's being created, the very fact that it has to be created means that it wasn't explicitly stated in the Constitution. And if it's not explicitly stated in the Constitution, then there's always going to be controversy about the relationship between doctrine and the constitutional text. And that's what we have here with substantive due process. Now let me give you a few more notes on legal doctrine. So legal doctrines come and go, depending on the composition of the court. Once SCOTUS mentions a theory, a legal doctrine, a principle, once SCOTUS mentions it, in a majority opinion, it can become a part of SCOTUS jurisprudence. All right then. So then, legal doctrine is precedent. Yes. Okay, legal doctrine is precedent. So then precedent, Professor Davis, you've said precedent is law before, and so do other scholars. So is precedent law, yes or no? Because if precedent is law, yes, then that means legal doctrines, because of their use as established precedent, it makes them indeed law. And so how do I answer that question? Well, I answer it with a yes and a no, both. Because whether or not you think precedent is law often depends on whether you like the precedent, especially if you're a Supreme Court justice. So common law places importance on stability. People need to know what to expect from the court. And the best way the court can do that is through creating legal doctrines, precedent, theories, standards, all right? And it's important to be able to expect the court to act in a particular way and to act according to the way it's acted in the past. To do that, though, and in order to do that, it is helpful and necessary for the courts to view precedent in the same way as law. But because it is not technically law, can precedent be overturned? Because the courts can't just overturn law, can they? Oh, well, depends on, how you subscribe to judicial review. Things are getting complicated, see? Anyway, so basically, is precedent law, yes or no? Is it important? Absolutely. Do the courts try to treat precedent as law? They absolutely do. If the courts overturn precedent, they usually really detail out why they're overturning that precedent. Sometimes they don't. Now, remember when we talked about, I think it was Gideon v. Wainwright and the Betts case, right? So we talked about that, I think, in chapter 11. And one of the dissenting opinions was that, yes, Betts should have been overturned, but Betts should have been given a lot more of a discussion in the majority opinion. There again, the court's trying to be really clear, and if they're going to overturn precedent, they better have a really good justification for it. Otherwise, basically, the foundation of law just kind of starts to crumble if we see the court just willy-nilly overturning precedent here and there. And here's what I probably look like to you when I explain legal doctrine in my common law class. But I'm telling you that it's really not quite like that. What I hope I look like more is, hang with me, Tabitha Brown. If you haven't listened to her TikToks or her cooking videos, she's freaking amazing. And she's so soothing with the way she talks. And so she's a vegan, and I'm going to tell you, I'm not vegan. Okay, I really, 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 really love meat. And it's a lot of work to be vegan. And if you watch Scott Pilgrim versus the World, being vegan apparently gives you superpowers. But at any rate, I hope that what I look to you is more like Tabitha Brown, who here is standing in front of her pizza bagels here, okay? And so when she tells you about a recipe and she makes it look so good, she makes it look so easy, she's telling you, here's what we're going to make, and here are my ingredients for it. Okay, so she'll start out, she likes to say things like, come on in the room. I'm going to show you how to make some guacamole, or I'm going to show you how to make some pizza bagels, vegan pizza bagels, and they're going to be so good. She has such a soothing voice. I can't even do it. Anyway, so here, what I hope I'm showing you is that I'm saying, come on in the room, class. I'm going to show you how to make some legal doctrine. Now, if you want some substantive due process, honey, that's your business, as she says. And again, very soothing. So I hope that what I'm showing to you is, here are all the recipe and the things that make up what we call constitutional law. If you look around, you're going to find that there are a lot of different recipes on how to make pizza bagels. Tabitha Brown here makes pizza bagels with purely vegan ingredients, even using vegan sausage. If you come to my house and make pizza bagels, I'll make mine with real Italian sausage and a lot of garlic. Well, garlic is vegan, but real mozzarella cheese, things that aren't vegan. And if I want to do that, honey, that's my business. That's what she would say, okay? But that's kind of how it is with the courts, like with the justices. Now, justices don't believe things willy-nilly, right? I mean, they have reasons for why they believe things. But my goal in this class for you, I'm just realizing, my teaching methods. Anyway, my goal for you in demonstrating to you what substantive due process is to make sure that you have all the ingredients that you can put together a solid understanding of what it is. Now, let me say one more thing. Sometimes whenever I demonstrate, or rather teach in this way where I tell you, here's what's out there, it seems as though what I'm telling you, to some students, it seems as though I'm telling you everything is relative. And I want to assure you that I do not believe that. And there's a lot of fallacy in believing that anything is relative. What I'm trying to tell you, though, is that some things are complicated and difficult to not articulate, but difficult to put into practice. That's what I'm showing. Now, there are absolutes. Most things aren't relative, okay? Law isn't relative. I think when you're looking at what is good law, the problem is, though, we don't often know what the absolute is sometimes. And if we don't know what the absolute is that we're trying to get to, it's best to look at, it's best to examine over and over again our processes, our institutions, our structures, right? Because that's where our results come from. Hopefully that made sense. Actually, I know it did. Yeah. So again, it sounds like I'm saying that, good constitutional law is relative. It's not. It's just sometimes complicated to articulate in law and to create legal doctrine. So, yeah, that's, again, I still look like that to you. Okay, so what is substantive due process? So you may think, well, you've already told us, but I just want to throw out a few other definitions. Substantive due process to some is a broad interpretation of the 14th Amendment or 5th Amendment. It's drawn from English common law traditions, and that there's these tacit constitutional protections of life, liberty, and property. And all of this kind of comes from, if you've ever read John Locke's letter on toleration, he talks about civil goods, life, liberty, and property. He calls it something different, though, at the time, and that's kind of where it's derived from, that this is what substantive due process comes from. If you look at Chereminsky, which is a PDF article that I put on Blackboard, you'll see that substantive due process asks the question of whether the government's deprivation of a person's life, liberty, and property is justified by a sufficient purpose. I kind of like that definition. And then lastly, judicial review. It is substantive due process to some is a judicial review of what government action substantively does to citizens. So did the law or government action arbitrarily, capriciously, unreasonably interfere with the rights of life, liberty, and property? That's going to sound awfully similar to what you read in your book, and it is. And if you think about it, all of these are they're all kind of saying the same thing. Oh, and there's me again. Now, how can you view substantive due process? If I'm giving you this complex explanation of a complicated legal doctrine, then how am I telling you to understand it? In this way. First, I want to point out that one of the reasons substantive due process is complicated is because when we think about substantive due process and the results that come out of it, the results are always controversial. So most controversial SCOTUS cases or SCOTUS decisions, the most controversial SCOTUS decisions in the past have concerned the use of substantive due process. And that's one reason that substantive due process gets so much attention, right? Because not only is SCOTUS looking at a very touchy topic, but they're using a legal doctrine that is not rooted in anything explicit in the Constitution. And there's a reason for that. If a case is coming up to the Supreme Court, you can bet it's not an easy case, right? I mean, SCOTUS wouldn't have taken up the case if it wasn't complicated in some way. The lower courts could have figured it out pretty easily, and there wouldn't be a need for a legal doctrine. Secondly, substantive due process is a function of judicial review. Now, I think this is a really important way to view substantive due process. And that's not Dr. Davis' philosophy. This is law school philosophy. Substantive due process is a function of judicial review. And judicial review, right, it's not said anywhere in the Constitution. Judicial review is about a lot of power that the federal judiciary has. It's and again, it's a controversial theoretical overreach of the Supreme Court. And think about this too. Where did we get judicial review? Well, Marbury v. Madison. I mean, John Marshall said we have the ability to use judicial review, and he laid it out. Now, some people didn't realize what exactly he was doing when he did that, but you look back and say, well, who are you to assert judicial review? Well, he's a Supreme Court justice. That's what he would say. And they would say, but that's not the law. And he would say it is now because it's in the Constitution, or it's not in the Constitution, but he would say it is now because now it's precedent. Now it's in an opinion, right? Now we've done it. So try to take it back because it's already precedent. Mind blown. Okay. Also, substantive due process concerns judging laws and government actions based on their reasonableness. Now, some laws, SCOTUS examines really strictly, right? So they decide what laws are examined really strictly, what laws are examined not so strictly, and we've talked about those. The Constitution doesn't tell us which specific laws are or should be examined strictly or not so strictly, right? SCOTUS asserts that, and we allow them to do it, right? So we give them this legitimacy. And then finally, and I've highlighted this, you can see that I think this is important. Substantive due process requires justices to make inferences from the constitutional meaning of life, liberty, and property. So this is where the controversy comes from. This is where, when you look back, hang tight, when you look back on some of these criticisms, right, about substantive due process, this is where you get some of the critiques of the Supreme Court as being a super legislature that's just choosing to weigh the wisdom of legislation, or that it's a made-up legal principle used by justices to justify their desired legal outcome. Because it's not explicitly stated in the Constitution, and look here at the highlighted portion here, the relationship between whatever doctrine's being asserted in the constitutional text is always up for question. If it wasn't up for question, it wouldn't be a legal doctrine because it would be a constitutional text. Like so, like that. That's your catchphrase. That's what Tabitha Brown says. And you just do it like this, like so, like that. It's so calming. You should definitely check her out. All right. Substantive due process requires justices to make inferences from constitutional meaning of life, liberty, and property. And anytime justices are making inferences, anytime the law requires anybody to make inferences, it gets messy. One of the reasons that people like the law, that people love the law, is because some people view the law as kind of like math. 2 plus 2 is always 4. 5 plus 4 is always 9. And people like that consistency. They like that certainty. People like knowing expectations. People like knowing what's required of them. But substantive due process requires justices to make their own inferences. And because justices change, because we have different Supreme Court justices coming in and out of the court, that's problematic because we see over time it changes, but it's also problematic too because we don't elect these individuals who are making inferences from constitutional meaning. And these inferences from constitutional meaning are either reinforcing or completely undermining seemingly legitimate legislative actions. What's the history of substantive due process? Epstein and Walker did a really good job of this. I mean, they do a good job with all of this. They're far more intelligent than I am. But I didn't want to go into too much detail. I pulled some of this from my other lecture. I did want you to know, though, remember, due process is about the Fifth Amendment and the 14th Amendment. Although typically when we think about substantive due process, we think about it with the 14th Amendment. It was first used in Dred Scott v. Sanford. So here we see substantive due process being used in not so good of a way. Basically talking about legislation that freed slaves, deprived somebody of their property without due process. And they're looking at the Fifth Amendment there. Okay, so we see substantive due process here. Right. So then we see, once the 14th Amendment's established, we see this economic doctrine that I talked about, protecting individuals with economic rights, whatever contract they want to get into. It was officially established. We see the court using the term in Lochner v. New York in 1905. And then the court kind of abandoned it after 1955. But then we see it resurface again when we start looking at the court's foray into civil rights, and we see it in terms of privacy, right? So typically when we think about substantive due process now, I couldn't list all the cases that use substantive due process because there are tons. But just for a few examples, when we think about the court asserting the right for parents to decide their own child rearing, that's from a Supreme Court case. That's based in substantive due process. The Cruzan case that we looked at in Chapter 9, competent adults refusing medical attention and the court recognizing that right, substantive due process. Adults engaging in same-sex relations, the Lawrence, I think it was Lawrence v. Texas case, that was about substantive due process. And so we look at some of these cases, and you may think to yourself, substantive due process can results in good legislation, right legislation, right? But some of these cases you can look at and say substantive due process results in rulings that when we look back, hopefully as a nation we're embarrassed about, i.e. Dred Scott v. Sanford. So anyway, I hope this was helpful in some way. If you have any additional questions about substantive due process, be sure and look at some of the links or the uploads that I provided on Blackboard, but you're also welcome to ask me those questions, and I can actually recommend some really good books for you to look at too if you're super duper interested. Oh, I sound really lame, super duper interested. Anyway, hope you're all having a great day and a good end of the semester.